Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, it's always awesome to be able to do videos about good news, and I had a nice little streak running of being able to drop video after video all announcing really good news. But then a federal judge in Washington State had to screw it all up because now I got some bad news, and it's for the hometown crowd, folks here in Washington State, because as we know, we were still waiting for one last ruling on our magazine ban, particularly in the case of Brumback v. Ferguson. You guys might remember we've been waiting on an injunction since December on that. Well, guess what? We got a ruling, and you ain't gonna like it. So today, let's spend a few minutes and let's get you educated on why Washington will still ban magazines. Okay, so here's the case we're talking about. We're talking about Brumback v. Ferguson. You guys might remember that case. If I had $1 for every time one of you asked, hey, when are we going to get a ruling on the injunction in Brumback, I would have been retired months ago. As you recall, let's go back in our time machine. 2 summers ago, we got a magazine ban shoved down our throat through Senate Bill 5078. There were 2 separate lawsuits that were filed. There was one in the Western District of Washington, the United States District Court. That was the matter of Sullivan v. Ferguson. That unfortunately didn't go very far. And then there was the matter in the Eastern District of Washington, which was Brumback v. Ferguson. Now, for those of you who've been geeking out on this channel, you will know that all the briefings and everything on the temporary injunction were due on December 16th of 2022, and we were going to get a ruling on December 23rd of 2022. How'd that work out? Well, here we are on September 25th of 2023, and lo and behold, hey, we finally have a ruling. It is 32 pages of garbage, and I want to make this clear. The court here has denied the motion for an injunction. So, on the heels of Duncan v. Bonta, where Judge Benitez absolutely shredded all of California's arguments. In this case, Judge Mary Kay Dimke of the United States District Court, Eastern District of Washington, has found that there's really no problem with Washington's magazines ban. Now, let us all remember that the statutes which are in question in Duncan in California are almost verbatim identical to the statutes that we passed here in Washington State. And for those of you who've geeked out on the channel, you know that we really don't come up with creative ideas here. We just copycat everything that comes from California. Now, I know you're sitting there going, how the hell did this judge deny this injunction? Now, let's just go back and simplify. What do we have to prove in order to win a temporary injunction? Number one, we have to show that we are going to suffer irreparable harm if the law is not enjoined, and 2, that we are likely to prevail on the merits. What the court has ruled here is that the plaintiffs here are not likely to prevail on the merits, and the reason is, and you're gonna laugh when you hear this, if you don't vomit in your mouth, is that magazines do not constitute bearable arms. So magazines, according to Judge Dimke, are not even protected by the Second Amendment. The court believed that this was incredibly unsettled areas of law, and that the plaintiffs' evidence was insufficient to establish that these are protected under the Second Amendment. So she has tubed the injunction basically on a sufficiency of evidence argument. It's a real backdoor way of just trying to get out of this thing, because I've had an opportunity to review the record. The record was complete. The evidence was there. She just tried to back her way out of it. As the court put it, these difficult and unsettled questions of law aside, plaintiffs failed to demonstrate their likelihood of success on the merits for a far simpler reason. A magazine is a part of a firearm rather than a weapon of offense or armor or defense, or a thing that a man wears for his defense or takes into his hands or useth in wrath to cast at or strike another. On its own, it cannot be used to attack or defend. A magazine with increased capacity simply reduces the frequency of reloads required when discharging a firearm. Yeah, I'm not making that up. That is exactly how the court ruled. Now, if you want to understand just how illogical the reasoning is, consider some of this ruling. It remains plaintiff's burden to establish that the weapon at issue falls within the Second Amendment's purview. Plaintiffs have offered insufficient evidence suggesting that the text of the Second Amendment was meant to include large capacity magazines. And much akin to what Judge Benitez did with Lucy P. Allen's 2.2 shot theory, this is what the court did to Brumback's testimony here. Brumback's declaration offers little more than conclusory assertions that large capacity magazines fall within the right to bear arms. And so to understand the intellectual integrity of what this ruling is really all about, consider this quote from the ruling. The gravity of the relief requested and the uncertainty of prior authority in Bruin's wake demands a renewed analysis that rests upon a reliable evidentiary showing. The court must insist that there be a historical record in order to make a determination on the meaning of the word arms as used in the Second Amendment. That's right. The court believes that we have to do a complete reanalysis, a historical analysis of what the term arms means. Now you can see how she is literally running from this issue. Consider also this part of the opinion. The court must insist that there be a historical record in order to make a determination on the meaning of the word arms as used in the Second Amendment, specifically whether arms includes magazines or large capacity magazines. You literally can't make this stuff up. Consider this. At present, the evidence in the record is insufficient to establish that plaintiffs are likely to prove that large capacity magazines fall within the Second Amendment right. The instant decision is primarily the result of plaintiffs' insufficient evidentiary showing and should not be read to preclude a contrary finding at a trial on the merits. It is pertinent to note, however, that no party at this stage has demonstrated a historical record adequately supporting their respective positions on the questions of whether the Second Amendment covers large capacity magazines. And I know that may come as a huge shock to you, considering the fact that this comes on the heels of another opinion in Duncan v. Bonta, authored by Judge Benitez out of the United States District Court for San Diego, that finds quite the contrary. Because this is exactly the same argument that the state of California made. Shocker, Washington's making the same argument that California made. How did Judge Benitez deal with this? Hey, magazines aren't even covered by the Second Amendment argument. Well, he dealt with it like this. While the Second Amendment does not explicitly mention ammunition or magazines supplying ammunition, without bullets, the right to bear arms would be meaningless. So this is much akin that if you had a constitutional right to a car, you don't, but if you did, but you didn't have the right to an engine, you see that right would be completely superfluous. Or as Judge Benitez put it, by extension, arms includes the magazine component necessary to supply the bullet into the chamber of the gun. Our case law supports the conclusion that there must be some corollary, albeit not unfettered, right to possess the magazines necessary to render those firearms operable. It is hard to imagine something more closely correlated to the right to use a firearm in self-defense than the ability to effectively load ammunition into that firearm. Or in summary, as Judge Benitez put it, put more broadly, the Second Amendment protects ancillary rights necessary to the realization of the core right to possess a firearm for self-defense. Consequently, whether thought of as a firearm able to fire a certain number of rounds because of its inserted magazine or as a separate ammunition feeding component, magazines are usable arms within the meaning of the Second Amendment. And let us not forget that in Duncan v. Becerra v. Bonta Part 1, and in Duncan v. Bonta Part 2, and even in what the full Ninth Circuit en banc panel said, everybody agreed that magazines constituted bearable arms. As Judge Benitez pointed out, leaving no doubt, even the vacated Ninth Circuit's en banc decision assumed that Section 323.10 implicates the Second Amendment. And of course, Section 323.10 is California's magazine ban. So even the Ninth Circuit, when they struck down Duncan v. Bonta v. Becerra the first time around, and that's how it ended up in front of the United States Supreme Court to be GVR'd back down. But even the full panel of the Ninth Circuit said, hey, when we're talking about magazines, we are actually talking about bearable arms as contemplated under the Second Amendment. So, of course, the question then becomes, what the hell do we do about this in Washington? Well, both the Duncan case as well as the Baird case was given to Judge Dimke late last week. I have a belief that much of the opinion had already been authored. However, the Baird case does appear in the footnotes and cited here. Duncan, of course, appears nowhere. Now, Plaintiff's counsel on this case could move for what's called a motion to reconsider. It has to be filed within 10 days, but that's going to be back before Judge Dimke, which may be akin to throwing rocks at the moon. The more likely move here is that the plaintiffs here are going to immediately appeal to the Ninth Circuit, knowing that the state of California is also appealing Judge Benitez's ruling to the Ninth Circuit. We are hopeful that we will see all of these cases consolidated. What does this mean for us in Washington State? Well, as good as the new ruling was on Duncan, and it is fantastic news, the actual remedy that we need to see here in Washington, we're not going to realize that for a while, because for the time being, Washington's magazine ban, RCW 9.41, 0.370, as well as 0.375, remains in effect. There is no injunction coming in the matter of Brumback v. Ferguson. Judge Dimke has ruled to the contrary on that, and onward and upward we must go. It is a disappointing ruling. It is an irrational ruling. It is an unintelligent ruling, and this is what we have come to expect from judges who are hell-bent on the civilian disarmament agenda. Listen, you may have more questions about Brumback v. Ferguson, Duncan v. Bonta, or anything else related to what's left of our Second Amendment rights. Now, you all should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is right down there in the description box. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.